Today, Hofstra is committed to being not only a national school, but an international presence and a player in the global community, to supporting and producing attorneys with not only the highest of academic qualifications and skills training, but also with a high level of professionalism, a professional identity, and a presence. Graduates with a keen awareness as to the business imperatives driving the legal community at this time. There's never been as saturated and competitive a legal market as our young lawyers are emerging to find. And one of our most important goals is to helping them differentiate themselves and to compete in this environment, as well as differentiating our alma mater and the law school. So with that said, and in this vein, I am very excited to bring to you this evening an incredible panel. We are so fortunate to have with us three key influencers and players in the legal community, each with a different vantage point and perspective, to discuss their view on the future of the legal industry.
I guess my vantage point, the future of legal practice and professional development is one from the big law refugee, for lack of a better term. I was formerly a partner in Matt Phillips & Phillips, which is a 450, 500 attorney firm with offices mostly on the West Coast, but also here in New York, and recently moved my practice out here to Long Island, Hock, Hamroff, and Horowitz about a year and a half ago. And much of that was driven by finances. From my point of view, obviously you've seen some upheaval in the legal marketplace in the last year and a half. Certain practice areas have drive up a lot of pressure from clients with respect to billing rates, which puts pressure on larger firms to compete. I think we're going to get into some of these issues, but lockstep associate pay, increasing billing rates every year and trying to push those costs on to clients year after year. I don't know that that model is particularly sustainable any longer, and it does create some pressure, I guess, in what I would call the middle class. But if you are, in my case, I was a non-equity partner in Matt Phillips & Phillips. If you're in that situation, almost by definition, if you're not an equity partner, you're yourself not a huge rainmaker or business developer. If you were to be an equity partner, your billing rates are going up because the firm has its overhead and its cost structure, and it has a billing structure. Clients start to rebel against that. The work needs to get pushed down to associates. And in my case, if you have a practice which is largely counseling driven, it is advertising marketing. Sometimes could be a 0.2 hours. Bill, we're going to put up this banner, we're going to post this content on our website. Can we make this claim? Can we say we're the #1 whatever site? It's day to day. You want the client to pick up the phone and speak to you all the time. If your rate over the 7, 8 to 10 years that you've been talking to that client has jumped, 100%, they don't want to pick up the phone and talk to you anymore. So you need to be conscious of that. And again, that can create some problems. If the work has to get pushed down to junior people, and you're not the person who's getting credit for the work that comes in the front door, you've got a problem. So in my case, the solution was to move to a smaller firm in a different market with different rate structure, where you could offer the same services to your clients, essentially for 2/3 of the price, and thereby be as profitable individually because the firm has much lower overhead than the big city firm. And if you consider a client, I'll do the same work I did for you for the last 10 years, but instead of charging you $600 an hour, I'll charge you $400 an hour. For the most part, they're going to give you the work, and in fact, give you more work.
Three trends that are changing the practice of law, and a couple of them were touched on by Bill, but one that should be obvious to everybody in this room is technology has had an overwhelming effect on the practice of law, and an exponential effect. And the speed with which it is changing the practice of law, I can't predict. I can only tell you that it is happening fast and it is changing the practice quickly. Technology has some great practical effects. It's untethered us from the office. You heard about virtual practices. Well, even big law firms are learning that as this market gets more efficient, and I face competition from people who are doing the virtual law firm practices, that we've got to get more flexible. Our associates, our partners have to be able to work from home, spend more time with their children. As technology simultaneously eases that burden, it increases the demands we're getting from our clients. I have been reading the eulogy of the billable hour from big law firms. It's a model that doesn't work anymore. The clients are putting pressure, the demands have decreased, and no clients are going to pay for this. This is the silliest business model, because if you went out and hired a contractor that's been doing work for years, they would never tell you, here's my hourly rate, here's what we do, and I can't give you a budget, I can't fix the costs, you just have to trust me, which is the way, candidly, big law firms had dealt with their clients in what I called, when I started in the profession, the country club practice, where most of the in-house lawyers were alums from law firms, and the in-house law departments were very small, and they relied on firms like mine to do all their work. Well, what is absolutely true is that there has been increased pressure on law firms to manage those costs. There has been pressure on us to find creative ways to add value to the client through either blended rates, capped fees, risk sharing strategies with the client. But nevertheless, what I have found, and the truth of the matter is, and Steve Brill wrote about this in The American Lawyer 20 years ago, that we would not have a billable hour structure at big law firms, and yet we still do, and there's a good reason for that, at least with big law firms that deal with large in-house departments. The person on the other side dealing with you is a lawyer too. With that, because there's some overlap, I have some definitive views on what I would call the big law firm of the future, and it does deal with the fact that I believe that associate salaries are going to change. The lockstep system is going to die in the next 5 years for associates, and we've begun to see it die at many large firms. I think more firms, particularly in New York, will go to a two-tiered partnership structure. I think technology will eventually bend, and it's going to provide a greater lifestyle benefit to us than it is going to be an impediment to enjoying the practice. I think that has to happen, and it has to give. And ultimately, I think diversity, at least at big law firms in the short term, is going to improve as it has been over the past decade, albeit slowly, but I think that we're on a big uptick, and that's a good thing for the profession.
So from my perspective, what I see in the future of law firms, and I've seen it, is much more, and you hit upon it, David, a corporate model. It is a business, and you know, there is more of a corporate model that's out there today, especially in the larger firms and trickling down to the smaller firms. And by what do I mean by a corporate model? You see many, many more equity partners years ago. Today, you see more non-equity partners, less equity partners. Shrinking of the ownership structure of the firm, more non-equity partners, more of counsels in firms that have an arrangement to be fairly compensated for the services they provide, and the ownership structure shrinking. And you see partners being de-equitized. You know, and you might say, well, some of those is the mandatory retirement age issue that came up, and the equity was taken away from them. But it's happened also in this economy where equity's been taken away. And that corporate structure, you've also seen large firms, very large firms, who said, you know, we're not going to take a lawyer inside the firm who and make them managing partner, but we're going to bring someone from the outside. If this was a public company, we wouldn't hire an engineer when we're manufacturing. They help us manufacture the product. But someone who's going to run the business, whatever the business model is, we're going to bring somebody in to run the business. And that is another, you know, it happens in the very large firms because they have the need for they can have that, they can support the administrative structure, but you see it trickling to the next tier down. So what does that mean? I think you're going to have less equity, you're going to have more non-equity, you're going to have of-counsel relationships, you're going to have you know, corporate kind of structure. Corporate kind of structure might mean someone, a non-lawyer, being the managing partner, the chairman of the board directing the firm. And I'll even go so far, and you know, I'll go a little bit out on a limb, and we'll see 10 years from now where I'm going to be. But what about public ownership or non-lawyer ownership of a law firm? I know I see it out there. Are you crazy? Okay, I understand. You're right. Lawyers cannot share fees with a non-lawyer. We understand that there are rules to abide by. But let's step back. Someone's going to figure it out. Why do I say that? One, there are investment groups out there today that go to the big law firms that have mass torts, litigation that take tens of millions of dollars to fund, and they've arranged with them to invest. I'll give you the $10 million to pursue this lawsuit, and in some way, shape, or form, we're going to get some investment return on that $10 million. Does it make them owners in the firm? No, but does make them some sort of profit sharing in that case and in that relationship.